Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody. Welcome to the September 2022 edition of the Third Fridays podcast. My name is Christian Cison. I'm your host today, and this has been a very, very crazy setup here because I'm so used to doing it in a very, I guess you would call it a low-budget style podcast. I actually have heard the recordings to see if this would be good, and this month's episode is now getting a bump up with the help of, I guess, the brain trust of Lois Law Firm. Seeing me walk around with the microphone and a laptop has prompted all the powers that be to give me all the best equipment and spend 30 minutes to set me up here nicely. And why not? We have a great topic today, and I have two of the most talented attorneys in our firm here today. Addison O'Donnell and Chris Major, welcome back to the show, guys.
Thanks for having us.
Yes, thanks as always. You know, I love being on this podcast more than anything.
Yeah, right. And Chris, how much are you keeping track of who has had the most guest appearances on the show?
My understanding is that I hold that title exclusively, but if there is another contender, I would like to know sooner than later.
Right, he's going to put in for more topics to be discussed. Yeah, it's pretty good, probably because you're so great at everything, Chris. But we're here to talk about an appellate division case that was issued, or the opinion was issued in February of this year. And typically we're so ensconced in how this affects our practice and all these opinions. The Appeals Bureau headed up by Addison is very aggressive in getting the news to the rest of the firm to make sure that we're giving the best updates and the best feedback to our clients. And this decision doesn't really do that per se, but it's so interesting that we almost were yelling at each other this morning for a few hours. Not like a friendly yelling, just like posturing over all the potential situations that could happen, right?
We get quite passionate about workers' compensation.
Right. And Addison, I messaged you very early this morning to see if you'd want to do this, and you said let's bring Chris Major into this too, because let's just increase the brain power in the room.
And there might be third-party implications. Chris brings.
Yeah, and let the record reflect that I was invited and for once did not insist upon myself.
Yeah, there you go. Right. So it's like keeping that tally of podcast appearances up for honest, good faith reasons. So the case for everybody is Temperio versus Bronx Lebanon Hospital. And let's just take a moment to cite or to recite the fact pattern that the appellate division gives us. I'm going to go almost word for word here. On June 30th, 2017, Henry Bello, a physician who had worked for the Bronx Lebanon Hospital from August 2014 until his resignation in February 2015, following an allegation that he had sexually harassed a hospital employee, entered the hospital wearing a white doctor's coat and a hospital identification badge, and carrying, among other things, wait for it, a loaded AR-15 rifle. Now, in addition to setting fire to the hospital's 16th floor nursing station using a juice container filled with gasoline, a juice container filled with gasoline, Bello shot Justin Temperio, who was a first-year medical resident at that time, shot and killed another doctor, and shot and wounded 4 other members of the medical staff, in addition to a patient. Temperio was shot in the abdomen, and the bullet exited his right thigh, requiring a hospital admission, surgical procedures, and treatment. After the mass shooting, Bello shot and killed himself. So forget about everything that we're going to talk about for just a second, and reactions to that fact pattern, go.
Well, my quick reaction is that there's a footnote that says Bello never worked with Temperio and they had no prior knowledge of one another. So Henry Bello went postal, and it is actually quite tragic because we have issues with security here. There's a lot going on here, and it's a hospital, so there's a lot of eyes looking at this. I mean, I'm shocked, I'm surprised, and and I'm sort of depressed about this. But how about you, Chris?
Well, I'm thankful Addison O'Donnell is offering the humanitarian viewpoint of this, because the civil attorney brain in me goes, well, wait a sec, the guy shot and killed himself. Who's the claimant going to sue then? But
my God!
Other than, of course, their employer, but that takes us to the crux of this very case, unless I'm mistaken, Christian.
Yeah. So you have a situation that's so explosive, right? And it turns out that we have multiple jurisdictions at play here. So, what happened, I guess, from Timperio's point of view? What did he decide to do as a result of this?
Well, in the following year, Timperio filed a suit against Bronx Lebanon Hospital, alleging negligent infliction of emotional distress, NIED, negligent hiring, training, retention, and supervision. And
I would just say, let's file those causes of action away in our cap for later, because they're quite relevant. But I'm sorry to cut you off, Addison.
Did you hear that, listeners? File it away in your cap for later. Yeah. Nice. Okay.
Foreshadowing.
Right. I was actually saying the foreshadowing was really also the footnote that Addison talked about as well, right? Absolutely. So he files a federal suit, right? And on the workers' compensation side, what happens?
Well, I mean, meanwhile, on the comp side, about 7 months before, the carrier filed a first report of injury, sometimes called a FROI. I prefer calling it a FOI. Make it the French, make it classy. But file a FROI form, which essentially indicates that that there was a purported work-related incident of sorts, and in this case, that a former employee had shot Timperio while Timperio was performing his work duties, and that the injuries required emergency surgery.
So they're reporting to the board that this happened. Who knows what's on that FROI? Are they saying they're accepting the claim? Are they just reporting it? We don't know that. But it gets to the point of a hearing, which purportedly results in the carrier's representative saying, we're accepting the claim, right? So, Chris, what would that mean? Just that sentence alone, what would that mean for the claimant's federal lawsuit?
So if the carrier is accepting the claim?
If the carrier is accepting the claim in the workers' compensation court, what would that mean for the claimant's federal lawsuit?
Well, so Section 11 and Section 29.6, and 29.6 extends the protections of Section 11 to co-workers and basically everyone else in the employer chain, including the carrier. Section 11 and 29.6 bar suits against the employer once comp is elected as the quote-unquote exclusive remedy. So you might have heard this referred to as workers' comp exclusivity as a concept. But basically, the policy rationale behind it is that once a claimant elects to receive workers' compensation benefits, which are effectively a form of no-fault benefits, right? That's the classic trade-off. The guaranteed benefits you get from a work-related injury, bars your ability to sue your employer, and that's sort of the bargain that everyone makes, right? The employer's damages are limited to comp, and the employee cannot sue the employer civilly. So once the case is accepted or established, the civil action in federal court, realistically should be dead on its face due to Section 11 and 29.6.
Yeah, right. So it's almost, would you say it's like a strategic move to accept liability on the workers' compensation side to avoid or really to apply that exclusivity rule and avoid what could potentially be much higher exposure on the federal side, right?
Absolutely. Absolutely. If the federal case was barred, right, this is, first of all, the federal court is different than the state court. In federal court, you need to prove a certain threshold of damages in order just to say that you have the jurisdiction to go, right? I mean, Chris and I can discuss diversity of citizenship jurisdiction until the cows come home.
Civ Pro, law school.
One of my faves. So, but that being said, on the workers' compensation side, you could do the financial calculus and say that the estate of the decedent can only receive a certain amount given the maximum, statutory benefit rate and, what's going on here, if there's survivors versus the jury verdict, amongst a jury of our peers in federal court, Southern District of New York, that could render, millions of dollars in damages,
And so here's the really interesting thing that Addison's touching upon from, a coverage perspective. So you might hear comp referred to as Part A, and the workers' comp policy is written with two different types of coverage in every single policy. Part A, workers' comp, Part B, employer's liability. Now, what's interesting about the way the New York workers' comp law is worded is that theoretically comp is unlimited, right? There's nothing that says, there's a maximum amount of indemnity benefits that can be paid on a claim. But like Addison said, there are statutory caps for weekly benefit rates and, there are different mechanisms an employer can wield to lower their exposure. But the entitlement to comp is theoretically unlimited. And so what happens is if you trigger this employer's liability coverage and have this, what is effectively a claim against your employer similar to workers' comp, but outside of the workers' comp policy itself, you don't get to avail yourself of those protections, limiting indemnity benefits to the statutory max per week and any other protections we would have. So you have this theoretically unlimited pool of coverage that, as Addison correctly mentioned, is going to be left to a jury to decide. And that's where you start to get into this realm of millions of dollars in terms of jury verdicts where, everyone on this podcast knows that, realistically your comp exposure is never going to come anywhere near that. So that's the really interesting thing from just a coverage perspective is the potential implication of the Part B employer's liability policy if this falls outside of the Part A.
Yeah, and so the federal court case moves to a summary judgment motion, right? Brought by the hospital to essentially say this is a work accident because we know from the appellate division decision is that motion was denied where the federal court says that there's no nexus. There's nothing connected to employment or work here. And so that kind of juxtaposed against what goes on in the hearings in the workers' compensation case where the judge is hearing from the insurance company's attorney and says, okay, you're accepting liability, that it's a workers' compensation case. It's an accident that's compensable in the workers' compensation law. I'm agreeing with you. I'm going to establish it. I'm awarding benefits for whatever you've paid, so on and so forth. And the claimant appeals, right? The claimant appeals that. In the most unlikely situation for your normal case, a claimant is not going to appeal an established case. And also, a carrier is not going to willingly accept compensability for an accident where it's very clearly at least triable to the notion that this gunshot wound or this event has no connection to the course and scope of Mr. Temperio's employment. That is so wild and radical. You have the claimant saying, no, this is not a workers' compensation claim, and the carrier saying, yes, it is. I want to pay you in the workers' compensation arena. Guys, I mean, how crazy is that?
I'm still shocked about it, and the reason why is because there seems to be a very interesting, nuanced issue that I could foresee. The first is when a carrier's attorney goes into the comp court, the carrier's attorney is not just representing the carrier, right? It's the carrier and the employer. And so maybe the employer is the same in the federal case. And in this case, that's the case, right? The Bronx Lebanon Hospital is in the federal case and is being repped here. But at the same time, the workers' compensation carrier here is not involved with that federal case, which might, unless there's, some communication that confirmed the strategy here on behalf of the carrier, this is highly unusual. This is very rare. And a claimant arguing that the case should be disallowed, that the workers' compensation court is not the proper forum here. And honestly, from what I can read from this public document, it's under the theory that the claimant did not prosecute the case, that the case was just automatically generated given the subsequent indexing. So initially, I'm just shocked. I'm still speechless about this. What about you, Chris?
It really is quite fascinating for a number of reasons. So, we mentioned Section 29.6 and Section 11 and the concept of comp exclusivity. So, you'll notice in this opinion that it says motion practice ensued, and the hospital's motion for summary judgment, which if I were in their shoes, I would have done the exact same thing in the civil case, right? Which is an immediate motion for summary judgment on the grounds of comp exclusivity. So that motion gets denied by the federal court because they make a finding that the injuries did not arise out of and in the course of employment. And any comp attorney or comp professional worth their salt, alarm bells are immediately ringing that there's a civil court somewhere out there adjudicating the issue of whether an injury was work-related, which we all know, and we've seen time and time again in every conceivable arena, that the Workers' Compensation Board has continuing, exclusive, and primary jurisdiction over any of these issues. And we've seen that, in a number of different contexts, including, Section 29 lien waivers or claims for no-fault benefits. I mean, we could go over all the ways this could pop up. But then conversely, we have a claimant who's saying, no, I swear this didn't have anything to do with my employment at all because of what Addison and I were talking about earlier in this podcast, which is the civil jury verdict is potentially so much more. But then you have the board saying, yes, it is work related because, Section 21 and that, board's going to do what board's going to do. Everything's compensable, right? And then the third department goes, no, we agree with the federal court. Turns out it's not work related. So it's just this very strange interaction of, conflicting viewpoints that overlaps with the concept of exclusive jurisdiction for the board.
Yeah, it's a situation where the federal court is making a finding and the board, or I guess from law judge to board panel, right, the carrier is going to be arguing that the federal court's finding doesn't stop them from accepting jurisdiction, right? And the board agrees, right? The board says that there's no estoppel or collateral estoppel concept from federal action to Workers' Compensation Board. And I know, Chris, you mentioned in discussing this with me earlier the proposed legislation at the feet of our governor in New York.
Oh boy!
You want to talk a little bit about that?
Yeah. So the latest in a string of hateful, uncarrier, unemployer-friendly legislation. Just this continued war against our ability to defend cases and limit exposure in the state of New York. So this legislation has actually already passed the Senate and Assembly. It's from May 2022. And now it's just awaiting delivery to the governor to sign or veto. But it's a very quick blurb. They're looking to add Section 118A to the workers' comp law. Effective findings and determinations in subsequent proceedings. With respect to an action for a workers' compensation claim permissible under this chapter, no finding or decision by the Workers' Compensation Board, judge, or other arbiter shall be given collateral estoppel effect in any other action or proceeding arising out of the same occurrence other than the determination of the existence of an employer-employee relationship. So, immediately when this legislation was proposed, me and Tashia Rasul, who everyone knows leads up our construction practice here at Lois, we were immediately processing the implications of this. And there's a number of things you can do on the civil side based on comp findings. For instance, if we successfully litigate that a certain injury, maybe like a consequential ankle to a knee claim, right? If we successfully litigate that that's not causally related, and then in a labor law claim, where the employer is also being sued civilly, the claimant tries to tack on that ankle injury as part of their alleged damages in the civil claim, and maybe they include it in their bill of particulars, we can hang up that finding from the board of no causal relationship and argue collateral estoppel and avoid having that included as part of the civil injuries. And the implications are more far-reaching than that. For instance, if the board adjudicates that, this is not a work-related injury at all, or better yet, that the injury never happened, right? The claimant's a fraud. We have surveillance showing him just standing there as the truck rolls past him and nothing ever happens, right? That finding that the injury never happened at all, that's an immediate basis for a summary judgment motion if a civil action is filed, even in a labor law claim. But what this is saying is you can't hang your hat on anything the board finds except for employer-employee relationship. And that is just so wildly prejudicial to, an employer or a carrier's defense efforts that, quite frankly, it boggles the mind and gets the blood boiling, at least for, we carrier attorneys, right?
Right. I do feel that, sometimes there's maybe a voodoo doll or like a dartboard somewhere where it's how can we make it more difficult? And let's just throw the dart and see where it lands and create some legislation with the lobbyists from our opposition. But I say bring it on. I kind of like being, having the hardest challenge here. If you're going to create all these statutes to try and make it harder for us, well, it's just going to give us more opportunities to be bigger winners. It's going to hurt so bad for the other side when we do win those cases against them. But very good rendition there, Chris. I think, in here, it's almost like a two-way estoppel street where, the appellate division is agreeing that there's no estoppel here, but they're finding that there's no accident and injury arising out of and in the course of employment. And I know, Addison, you'll get a kick of this statement just as an appellate genius here, right? I love reading this sentence. Here, the mixed question of fact and law that is raised concerning whether Temperio sustained an injury arising out of and in the course of his employment is unquestionably a matter for the board to decide in the first instance. I mean, it's just like setting yourself up. You imagine reading a book, like any kind of book, and then you read something and you're like, I can't wait to read the next 5 pages. Like, that's how I felt when I read that sentence.
I mean, and this goes to what Chris had just said, right? The idea that collateral estoppel is on the chopping block for the comp courts, and then you read something like this where the appellate division cites not just a plethora of case law in which collateral estoppel has been used before, but that the mixed question of fact and law is raised whether an injury was sustained arising out of and in the course of employment. I mean, I just have to say, can the legislature even legislate on throwing out a justiciable, concept, right? Like this is something that gets my blood boiling, is that the legislature can't just overthrow case precedent just because it's not advantageous to a certain party who might potentially wind up in the court. That in and of itself is a bare desire to harm, quite honestly. It makes no sense to me, because if collateral estoppel is inapplicable, that means that the orders and the judgments made in the comp courts, right, are final. And honestly, it doesn't give any finality, any due process to one side of the table. And so I'm sort of mixed on this, because part of me feels that if this got to the courts, if a legislative mandate saying that there's no such thing as collateral estoppel got to the courts, it would be overruled, because that's a court mandated concept. Anyway.
Yeah, so this is the equivalent of just like a legislative declaration that some form of legal doctrine is wholly inapplicable. Like it's the equivalent of saying, there is no such thing as the coming and going defense anymore. Sorry, see you later. But reading between the lines here, Mr. O'Donnell, am I hearing that you would challenge the constitutionality of this legislation if given the opportunity?
I mean, I would at a state level. I mean, the idea is that, a full and fair and final determination is the due process right of anybody before an adjudicator, right? That's essentially the Constitution here. And if collateral estoppel is on the chopping block, just generally, right, then you get cases like this, right, where, of course, the courts, say collateral estoppel, disappeared, say it was on the chopping block, and this similarly situated instance wound up before the appellate division, they wouldn't be able to use collateral estoppel as a justification for jurisdiction before the board. They would have to conjure up its own way to do that, its own logic, or it would honestly establish the case. It would bar the claimant from pursuing in different courts.
Now, Christian, we're always going to look for the silver lining, even when we're constantly under siege by very claimant-friendly legislation and case law. But to the extent that there's any silver lining, and let me know whether you agree with this assertion, how often do we see the board and the third department finding any excuse at all to establish a case and claim that there is a nexus? And yeah, we'll have these intentional assault cases, and we'll argue, this is motivated by personal animus. It has nothing to do with their jobs. It's solely a personal dispute, right?
Right.
And how many times do we get shot down on that argument? So
every single time.
Yes.
It's almost an impossible defense to raise if you're doing that alone, right? When we tell clients that you have that defense, we're saying, do you got anything else? Because if this is it, we'll do our best. But the fact that we would just be going that makes it so difficult because, and the court really discusses it, right? So long as there is any nexus, however slender, between the motivation for the assault and the employment, then there's going to be a compensability finding. It's going to require something like this where the claimant is asking, hey, don't establish this. That's the craziness of this defense, that you can't win unless the claimant helps you.
Yeah, and you'll note in the language after they cite that blurb about so long as there's any nexus, however slender, the very next sentence in this decision is, here, however, such nexus is lacking. So even though the board established the claim, the really remarkable thing here is that the third department reneges on it. And there's one thing I do want to touch on briefly, and apologies if this is something of a shameless plug for civil practice, but a couple months ago, we prevailed on a summary judgment motion on the issue of comp exclusivity in a very high exposure general liability case. And it included making a tenuous argument of general special employment. You can check out the webinar for details. But one of the interesting things...
Humble brag.
Yeah, one of the interesting things I came across in litigating that case was this concept that, an intentional assault doesn't necessarily remove something from the protections of the workers' comp law. There's a line of cases, Orzechowski, Legault, there's a Werner versus State. There's this whole line of cases that say, sorry, claimant, the moment you accept workers' comp benefits, right, the moment you accept the benefits, and we talked at the start of this podcast about maybe a strategic move by the carrier trying to accept the case and establish it. The moment the claimant accepts comp, he is elected one of two exclusive remedies, and there can be no further suit against a coworker, the employer, or the carrier. So really, to touch on your point, Christian, the fascinating thing about this is that you're right. If the claimant had even accepted 1 week of indemnity benefits, all of a sudden the employer is out from any sort of civil action thanks to 11 and 29.6. But the claimant actually is making the argument here, don't do that to me, board. This totally isn't work related. It's just such a flip-flop of what we normally see. It's just really quite interesting.
Yeah, and just to get back right to the fact pattern, right? Because we're talking about a lot of legal theory here, and I know there's going to be some people listening that are kind of not. I don't want to say they're behind, but it is hard to keep up with all the legalese, right? So we still have right and the appellate division goes out of their way to say the attack was perpetrated by an individual who was not employed by the hospital at the time of the attack and had not worked there for over 2 years. Was not and never was Temperio's coworker, did not know Temperio, and provided no reason for the attack prior to taking his own life. Nor did Temperio know the attacker, and there's no evidence the attack was based on an employment-related animus between the two individuals, or that the attack had any nexus to Temperio's employment or performance of his job duties. And, if we can almost just take a step back and talk about one of those sentences there, there was no reason for the attack prior to taking his own life. Are we expecting Dr. Bello to write a suicide note and explain that this is a work-related assault?
I absolutely agree with the line of thinking that you have, Christian. The idea here is that there's an entire first page of this opinion that links together someone who had dressed up as a doctor, had access to the building, walked in, right, and essentially committed these heinous acts, and the court, notwithstanding the first and second paragraphs of the opinion, says that a nexus is lacking, however slender, right? I shake my head, I sigh, because however slender means however slender, right? In order to link together, what does the court want? Do they want a rational motivation as articulated by Bello himself? I mean, it's ridiculous. It's ridiculous.
And Addison, I'll take it a step further. If the court's going to go and say, that there is no evidence that these two had any sort of relationship, Temperio and Bello, right? There's no evidence of any sort of personal animosity between the two. Well, doesn't that go to the argument that it actually is work related? Aren't we normally trying to argue exactly right. that there is personal animosity?
That's exactly right.
When we're trying to get these cases disallowed. So it's really
otherwise Bello would have went to a different hospital.
Right.
Exactly.
No, it's a great point.
Otherwise,
they started off the opinion saying that he resigned because he was accused of sexual harassment of a coworker.
Yep.
So he puts on his doctor coat.
Yep.
He's got a badge. He walks in. He's not walking in to a hospital in New Jersey.
Right. Or Grand Central Station. Or right anywhere where there's people. Right. There is a link. However slender.
Bringing it back.
Exactly.
And it bothers me. Now, there is something I want to say. This case got reversed at the appellate division level. So
right. So good point. So we I don't know if we actually delineate or talked about the opinion of the workers' comp, the appellate division, right? So they reversed saying what?
They reversed and they said that this case is not compensable. It is disallowed. I do want to note here, right? The carrier here filed a FROI, noting that the claimant, the claimant underwent emergency surgery, right? So we have the cost of the medical, we have the cost of the treatment. Now it's a decedent, right? So there's not necessarily any indemnity that I could see right now. There's no survivors and no estate that's pretty, that's developed here, but who pays for that emergency surgery? The carrier paid for it, so now the carrier has a viable claim to go to the state, to go to the New York Workers' Compensation Board through the Section 151 fund and say, fund, you made an error in administering the law, pay me back.
Oh, I didn't see where you were going with that. I thought you were going with advance payment of compensation. I paid a medical bill, so it's a compensable claim.
And an advance payment of compensation only can be overruled through a no causal relationship argument, right? Which they go into detail here. They cite Section 21 presumptions, but they also go into the causal relationship argument immediately.
So Addison, I'll take it a step further. Christian's going with advance payment of comp. He thinks that's where you're going. You're going with reimburse us because of this error of law.
Exactly.
You know where my mind goes, Section 29, right? Because nothing in Section 29 is predicated upon compensability of the claim. If you pay voluntarily and then the claim is ultimately disallowed, you still retain a right of reimbursement as to those benefits. And to take it even one step further beyond that, an employer who is sued for an intentional wrong, that actually the workers' comp carrier is permitted a right of reimbursement against that intentional wrong suit. Even though it's their insured, you can't subrogate against them because your policy says you can. But if the claimant recovers against the employer for an intentional wrong, the carrier has a Section 29 right of reimbursement on what it's paid. Again, nothing in Section 29 is predicated upon compensability.
How many people are listening to this podcast going, those lawyer nerds?
I know.
I you bring that up, but you realize we still haven't touched on the causes of action, which I did say to file away in our caps for later.
I was just going to say,
right,
what about the negligence?
Let's take the cap that's in the corner of the room with Chris Major's little notes. Let's unravel them. And what do you want to talk about there, Chris?
Okay, so I will make this brief because I feel like I've been monopolizing a lot of the discussion, but you can tell I'm very passionate about what I do here, right? So we have three causes of action: negligence, negligent infliction of emotional distress, and negligent hiring, retention, training, and supervision. So we now have the third department, right, saying this isn't a comp claim. So, if you're writing a comp policy and it simultaneously includes the Part A and Part B, the Part B employer's liability, you're going, well, shoot, we just lost the protections of the workers' comp law to limit our exposure, and now it goes into civil court. Well, now what happens next for our Part B policy? To what extent is that triggered at all? How might we still be liable to pay on this case? And the answer is quite nuanced because technically, this negligence claim based on an intentional wrong is going to trigger a duty to defend. But every single policy for Part B coverage includes what they call exclusion C5, which excludes, bodily injury that is intentionally caused or aggravated by the insured. So you still have to show up and defend, but you may not have to indemnify if you can get a declaratory judgment on the C5 exclusion. So there is still hope for the Part B policy. But to take it even further than that, negligent hiring, retention, training, and supervision, and negligent infliction of emotional distress, those are not bodily injury. Those would not fall under Part B. So what you're going to find happening here is that the employer's employment practices liability insurance, EPLI, is going to be triggered here. And then you're going to have a joint defense, right? You're going to have two carriers sharing in defense costs. One on the negligence claim, which triggers the Part B, but might be excluded for indemnification purposes, and the other on the infliction of emotional distress and negligent hiring retention claim, which is an employment practices liability claim. So, my mind is just spinning with the potential civil implications just based on the various causes of action alleged. That's how much these things can just branch off into tangents,
Yeah, there's not much more that I like than Chris Major citing legal statutes and Addison O'Donnell talking about legal theory. This has been quite the theater for me to get a front row seat. But we have a reversal, right? It's going to be remanded to the board to formally disallow the claim, or maybe the board will issue a decision that will comply with the appellate division's decision. And I guess this matter is put to bed. What do you guys think?
Well, let me ask you gentlemen a series of questions. Do you agree that there is a duty between the hospital and the decedent, right? Where the hospital had a duty to secure the facilities and so that the decedent who would have been alive would have been okay, would have been safe?
Absolutely.
Chris, do you agree?
That's an interesting question because if you're talking about the general duty owed to keep premises reasonably safe from dangerous conditions,
correct.
Yeah, that's
All right.
a component of your average negligence claim.
So we agree on this. We agree on this.
But also, the negligence turns on foreseeability, right?
Well,
so
I just
how
want to
foreseeable is it that a guy shows up with a juice container filled with gas and an AR-15 years after his termination?
But we
you know
agree,
what I mean?
We agree that there is a duty.
Right.
All right.
Correct.
Now, did the hospital have a duty to report Henry Bellows' sexual harassment allegation to the authorities?
Ooh,
That's a tough one.
yeah, I think that might be too smart of a question
So
for
the
me.
reason-
I don't usually say that, but because here's what I think you're getting at. Well,
If you agree, if you say yes, then the nexus is not slender. The nexus between what the duty that the hospital owed to the claimant and the duty that the hospital might have owed to the perpetrator, then how can you say that there is a no slender nexus, that there's no nexus whatsoever to have this case compensable?
oh, okay, yeah, I see what you're saying there. It's more making the nexus viable,
Yes.
right?
Then the slenderness of the nexus is there must be a nexus because there is a duty.
right.
But again, collateral estoppel. In one case, maybe duty is proven, but it cannot be, used in the other case. And this is the hole that they want to fill. And I'm mad at that slender finding there.
I have one question for our resident workers' comp litigation guru, Christian Cison, who will try any issue at all just for the sake of creating havoc.
I don't know. Addison sometimes tells me that I've been getting a little soft in my old age.
You settle too much.
Addison's had to see some cases that we worked in litigation go to settlements, and he thinks I'm getting soft. I just want everybody out there listening to know that that's not true. So thank you, Chris. Thank you for that.
I have never in my life heard anyone describe you as soft, but
there you go.
Here's an interesting question. Addison's talking about this slender nexus, right? And we talked about how difficult it is to succeed on this defense that the injury was not work related because it was motivated by personal animus of some sort. To what extent, if at all, Christian, do you see this decision impacting the viability of that defense when we raise it? And could you find yourself citing to this case when you're writing your memo after trial saying that this accident was motivated by personal animosity? Do you think you might be arguing this decision at all?
I think you have to try, of course, but I actually don't think it changes the practicality of a workers' compensation law judge's decision-making process. What we have here is what we all believe to have some nexus, and in some cases more than a slender nexus, right? And the appellate division almost like leads us down that road, right? They give us very many facts to kind of make us think that the foreshadowing is actually that there is a nexus, that there is something compensable in the work-related arena. So from what you're getting, we really talk about personal animus between two coworkers, where we say, you hit on my wife at my house the other night, and now I'm going to assault you, and we're on work premises, right? And then when we go litigate that case, Chris, right, we're talking about the fact that there is a personal animus between these two coworkers, and the claimant's attorney is going in there and saying, no, they were also talking about the fact that one shift ended too early and the other one started too late, and there's some thing that's in there that a workers' compensation law judge will actually find credible, right? So when they're going to take that, however slender nexus, if they can say anything about work and we can't disprove, if we can't disprove that, then those cases are going to be established. But I am kind of thinking in that mode, Chris, because they're kind of using prior case law to find what the claimant wants.
Right.
And so how often does that happen to us on the employer side, where we're asking for something and we pull out all the case law, all the statutes, But if the claimant doesn't want it, that's where I was going to before, right? They're doing this. They're using this case almost as a model where it's like this defense can only work if the claimant wants it to.
Right.
It's insane.
And that's that, at the appellate division level for workers' compensation claims, the Workers' Compensation Board acts as a party, right? That can and has and does submit briefs defending its decision. And so the Workers' Compensation Board is defending the decision to render this case compensable, and then the board itself gets reversed. It's
with the assist of the carrier.
With the assist of the carrier. I mean, it's actually once in a generation, dare I say, where these arguments are forwarded, and I don't expect another case like this to come out in another generation.
Yeah, I mean, it's so wild that I felt motivated to message you before 6:30 in the morning.
Oh yeah,
and to see what this case means to you. Yeah. And
I'll bet you regret messaging me.
No, of course not. I was actually thinking that we would talk about just the incredulousness of the juxtaposed positions, and it was actually you, Addison, that said, well, there's so much civil issues, so many civil issues that are intertwined with this. Let's get Chris Major and make this podcast even longer. And I was like, yes, let's do it. And then we walk across, we have our microphones and our laptops, and Greg Lois himself is like, no. Let's get you basically like stadium seating. Let's give you the best equipment and, making it a better production than what I usually have in my office with my one microphone.
And here we are.
Guys, I think that can put a ribbon on it. I know that if we could, and we probably might, to be honest, we might just talk about this case for a much longer time, but I think we've cleared up the issues for our listeners here today. So for Chris Major and Addison O'Donnell, and a shout out also to our friends here in the office that really set us up, Greg Lois, Lauren Rella, Kendrick Castro, John Grayson. This is Christian Cison reminding you to defend from day one.